Thank you very much, Mr. Chair. Nearly 50 years ago, the Supreme Court recognized the constitutional right to an abortion in Roe v. Wade. That ruling, anchored in our Constitution's right to privacy, was part of a litany of cases forming the doctrine of substantive due process, guaranteeing constitutional protections for many of the freedoms that we embrace and rely upon in the modern United States. Whether it be a parent's decision on how to raise their child, an adult's decision to marry the person they love, or the decision to use contraception, these private, intimate choices have long been left to the individual to make for themselves, not to politicians. In the week since Dobbs was published, I can tell you that the people of my district in Arizona are angry. They're angry because the Supreme Court's decision to overturn Roe reverses years of hard-won progress and precedent. It threatens the lives, careers, and families they've built, and the plans they've made for their future. Simply put, it turns back the clock. While Justice Alito attempted to distinguish the right to an abortion from other personal freedoms recognized by the court in recent decades, like access to contraception, like marriage equality, his distinguishing rationale was so weak that there is little hope that other personal liberties will hold up to its scrutiny. Make no mistake, the Dobbs decision is a clear invitation to state legislatures to pass more hostile laws that, without a doubt, will result in litigation before the Supreme Court and will result in further fundamental rights being stripped away. You don't have to be a close observer of the court to know this. Today's Supreme Court majority will not stop at overturning the right to an abortion. Now, the court feels empowered and emboldened to ignore stare decisis and rewrite settled law. From Meyer, the case protecting parental decision-making, to Griswold protecting access to contraception, to Loving protecting interracial marriage, to Lawrence protecting privacy for intimate relationships, to Obergefell protecting marriage equality, a century of stare decisis is at stake. So now it's up to us, members of Congress, who are duty-bound to our voters, to take immediate action to secure our fundamental liberties through federal statute. That will require abolishing the filibuster, but protecting constitutional rights is more important than protecting our archaic rule of the Senate. Our Constitution, our country, and the American people demand it. I have a question for Mr. Obergefell. You're a legend. You've changed America for the better, so thank you for your leadership. I want to acknowledge that first and foremost, your courageous action. Do you trust Justice Alito's assurance that rights of LGBTQ plus people will not be overturned? And if so, why not?
Not one bit. He clearly is opposed to marriage equality just based on his dissent in Obergefell. And regardless of what he puts in writing in this Dobbs decision, this decision opens the door to attack marriage equality. Justice Thomas's concurring opinion gives additional language and groundwork to do that. And to be fair, several of these justices during their confirmation hearings were not completely truthful, in my opinion, in their responses to their opinion on precedent relating to Roe versus Wade. So that piece of writing in that decision does not give me any comfort whatsoever. When one right is lost, all rights are at risk.
Ms. Warblow, essentially the same question. Justice Alito's pronouncement in Dobbs that, quote, nothing in its opinion should be understood to cast doubt on precedents that do not concern abortion, unquote. Does that offer you any reassurance that this Supreme Court majority will not roll back protections for LGBTQ plus people?
It's important to note that the majority opinion is a consensus document. It does not reflect what Justice Alito might have written had he chosen to write this decision alone. He and Justice Thomas have repeatedly said that they believe that the Obergefell decision was wrong. Not only did they say it in the dissent to that opinion, but they've said it subsequently, including in subsequent court filings. And so there is every reason to believe that they very much would invite and would like to see that precedent overturned, along with other precedents, including Griswold and Lawrence.
Thank you so much.
Time of
Yield
the
back.
gentleman has expired.